Hi, Carolee.
Hello, how are you?
Good. How are you?
Good. Well, I'm very excited about today's group and the masterclass that you've got for us. I will just wait for more people to come because I know that there's a lot of people here who are wanting to be in the group as well. So when it comes to cost agreements, I know that most law firms have their cost agreements from old firms, or they add a few together, and we all might be embarrassed to admit it, but I think that that's what most firms do. And it's especially initially when you're a smaller firm and you're just starting out and you're trying to save money and all of that kind of stuff. Most practitioners do take precedence from their past firm, and I will admit that our cost agreement is one that we've created over years from all sorts of different cost agreements. So you might look at our cost agreement, Jennie, and think, oh my gosh, what are these people doing? But that's the truth, right, when it comes to cost agreements. And I think that it's really great to have your expertise, and I would love to hear more about your career before we get started, your career, your expertise, and what you've done and you're around the cost agreement space.
Yeah, sure. Thanks so much, Carolee. And hi, everybody. It's just an absolute delight to be here this morning and talking about costs agreements. Boring for most people, but I love them. They just really float my boat. So do forgive me with that little oddity. So I was admitted to practice in December 1988, and I had a first few years of practice in large and medium firms in Sydney. And then I wanted to work part-time, and finding a part-time job was scarce as hen's teeth in those days. And I got offered a 3-week part-time contract at the Law Society of New South Wales, just mopping up a few complaints when there was a legislative change. And oh boy, it was just like a light bulb went off. I just loved working there. I very quickly got a job as an ethics solicitor, as an assistant to the senior ethics officer then. And so I stayed there for 12 years doing nearly always ethics and complaint handling. We moved to Victoria in the end of 2006, and I got another temporary job that turned into the Legal Services Commissioner, that turned into 17 years. And in the course of doing that, I've just done all sorts of really terrific things, handling a lot of complaints. I used to manage the front end of the complaints and inquiries section, which was, I'll talk about that a little bit more in my presentation. And my last role there was as manager of innovation and consumer engagement. So doing that, I really sort of dived into what the consumer experience of legal services was like, and started doing a lot of work to guide and help legal practitioners if they want to do things differently. So I left there at the end of November 2023, and I was very keen to start my own firm. I've always thought there's a gap in the market for lawyers, assistance to lawyers with compliance, and really doing a good job with things like costs agreements. I think, the small law firm is just the backbone of the legal system. It's the only real involvement that a lot of people have with the legal system. And the people who've actually used a lawyer are overwhelmingly positive about them. But I think we also have some pretty bad tools to work with. So that's my mission, is to improve the tools that lawyers have to work with. So that's me.
That's awesome. And so in your bio, you say how many complaints you have dealt with over the time. How many complaints have you dealt with?
Well, when I was in the manager's role, so personally dealing with complaints would be in the hundreds, but when I was in the manager of assessment and resolution, I triaged all the complaints. So I would have read about 14 or 15,000 complaints over 9 years.
Wow.
So it's a pretty incredible data set.
Yes.
And I think all of us lawyers know that when you've been experienced in an area, you see the patterns almost intuitively very quickly. So, so I know in intimate detail what cheeses clients off.
Right, yeah. And for us as law firm owners, I'll let you get on with your class in a second, but for us as law firm owners, I know that when you receive a complaint, either a complaint that happens inside the firm, or if they go to the Legal Services Commission, it can feel very personal.
Yes.
And it can be, especially if you're the one who's been doing the work, and then they complain about the work that you've done, or so what's your sort of advice around that for lawyers who are receiving a complaint? Because that's something that, people lose sleep,
Yeah.
and lose focus in their business because of this one complaint.
Yeah, look, that's absolutely right. I actually wrote a blog piece about this. So I've got a reference to that at the end of the slide pack that people will have access to. But I think the most important thing is to just to stop and to manage your emotions, and to really listen to what the client is saying, because it's often not a non-compliance issue, so it's not the sort of thing that is generally going to have an impact in terms of a disciplinary finding or anything like that. But it usually means that there's been something gone wrong in the relationship. So the vast majority of people who complain are, novice users of the legal system. And it's usually because there's been an issue that's gone wrong with the lawyer, that trust has been lost for certain reasons. So I will talk about that in more depth towards the end of the presentation. But
all right, well, let's get
yeah.
your slides up and let's
All
get
right.
started. And
So I'll share my
I'll mute
screen.
myself. If
Okay.
anyone has any questions, please pop them in the chat. I will be checking as we go. Now, Jennie, would you prefer questions to be at the end, or would you prefer that I interrupt you and ask you questions as they're relevant to what you're talking about?
Yeah, the latter. Interrupt me and ask questions. I always like a conversation. And if people want to come off mute and ask the questions directly, that's even better. So
Awesome. Great.
love a good discussion.
Great.
All right, I'll share my screen. Okay, so everybody can see this? Excellent. All righty. Okay, so thank you again for having me this morning. I really hope this will be a useful presentation, a useful class for you. Hang on, just hold on 1 second. All right, yep. So as I mentioned before, I took 29 years worth of learning from legal profession regulation, doing all sorts of roles. And my law practice, The Lawyer's Friend, is really aimed at helping lawyers like you to do business in a really good way. So the sorts of things I do are costs agreements packages, policy reviews, process reviews, all the things that you need to help you manage your law firm better, and make sure that you've got all those niggling worries about your compliance issues and regulation dealt with appropriately. So that's my mission, to help lawyers like you. Okay, sorry, I'm just having a little bit of difficulty navigating the slideshow, but that should be right. So as mentioned, I dealt with 14,000 complaints during my career. So that gave me an incredible breadth of data. So the vast majority of complaints are really to do with personal law matters. It's pretty unusual to get a complaint about a large commercial law firm. Most of the lawyers complained about are in small firms doing personal law matters. And there was just this incredible breadth of data that came out of it, and patterns that emerged over and over again. The vast majority of complaints do have something to do with costs and service rather than directly a disciplinary issue. Another thing that I did that was really useful, a couple of years ago, I did a deep dive study into 19 completed costs complaints. So these were complaints that went from beginning to end. What we did was reconstructed the engagement process. So we reconstructed a timeline from the documents that we had, and we could go right from the engagement to the point where a complaint was made and see what was the point at which trust was lost, at which things went off the rails. So that was an incredibly valuable exercise to really understand the root causes of costs complaints and what goes wrong in these sorts of things. And I think we can learn an enormous amount from cost complaints. There's a lot of things that are observed along the way that will help you to understand, problems that you can avoid. You can really flip the learnings from cost complaints on their heads and transform it into fantastic connection with your client. So what you're going to learn today in the class is things about how to build successful engagements. So that doesn't just involve your costs agreements, but the process involved in building a successful engagement from beginning to end. We'll talk about the value of having a good costs agreement and how that can really contribute to that. So a good costs agreement is what I would call essential but not sufficient. So having a good costs agreement will really set you up in the right framework, but there's a lot more to it than that. The context and the relationship really matter. And finally, we'll talk about navigating the roadblocks. Sorry, was there a question there? Okay. So with the costs complaints, the interesting...
I think you're on mute, Jenny.
Where has she gone, Jenny? Oh, there you are. Hang on, Jenny. Just go down to the bottom of your screen and there's a mute and microphone button. There you are. You're back. Sorry, Jen. There you are.
Okay.
It was absolutely my fault.
Sorry.
Someone came in and then I could hear them in the background, so I tried muting them and I accidentally muted you.
Oops.
Sorry.
Okay. So what I was talking about is the most common areas for costs complaints. Family law is head and shoulders above everything else. So that's 30 to 40% of the costs complaints. The consumer complaints are around 60% of the complaints that come in. So following family law, you get wills and estates, personal injury and conveyancing. And the thing that all of these areas of law have in common is that it's a forced purchase from the client. They're dealing with a situation that involves high emotion. They're very unfamiliar with legal matters and how they run. It's very high stakes for them personally, and they're often experiencing a significant degree of vulnerability. The other thing to note is that a cost complaint is always a symptom of something else. It's not just the sum of money. There's perceived poor value for money, and that's the thing that we really need to dig in. Why did the client think that the services were poor value for money? So I don't need to tell you why you want to avoid a complaint. They're a real headache. The complaint process can be difficult and stressful, as Carolee mentioned. It costs you time, money, and stress. You could be doing work with clients that really appreciate you and enjoy your services, as opposed to having to put together a response to a complaint. And often you've got some uncertainty about the sorts of things that you really need to include in your response to the complaint. Another thing with a complaint is that bad news travels fast. Unfortunately, unhappy consumers are far more likely to tell their friends than happy consumers. So it's really something that you don't want to have. And it's general all-around bad vibes for you as a lawyer. And for your firm, I think, as well. So what is involved in building a great client relationship? We need to understand first what the average client thinks before they need a lawyer, where they're at when they need a lawyer, how you start the engagement well, which includes with your costs agreement, understanding what can go right and wrong during the engagement itself, and then thinking about how to handle roadblocks and complaints. So what does the average person think about lawyers before they need one? The Victoria Law Foundation has done us an enormous service with the Public Understanding of Law survey. So this is a fantastic piece of research. They spoke face-to-face with over 6,000 Victorians about their experience of lawyers and the legal system. There's 3 volumes of reports so far. The latest volume was just released on Tuesday night. They are a really fascinating read. But in volume 2 on consumers' understanding and capability, they asked some questions about accessibility of lawyers, so how easy it is to get a lawyer and to understand what they do, and trust in lawyers. What is it? And they didn't just ask, do you trust lawyers, which is a bit of an open-ended yes/no question, but they asked, what do they trust lawyers to do? And here's this really interesting figure. So the extent to which the respondents trusted lawyers in Victoria. So I trust them to act in my best interests. The vast majority agreed or agreed strongly. I trust them to be knowledgeable and skilled in their work, an even higher percentage. I trust them to, or I expect them to act ethically and within the law. Huge figures there. Vast majority of people do expect that. I expect them to exploit loopholes in the law. Well, not many people do actually expect that, and very few expect you to break the rules if needed. But the one problem there, look at this statement, I trust them to not overcharge me. There's about 40% of the people in the survey couldn't agree to that question. So I think that's an area, that's something to be really, really conscious of, that when it comes to trust in lawyers, one area where we really fall down is on clarity about the cost of the process. So that's very interesting research. So where is the client at when they need you? They're coming to see you on one of the worst days of their lives. They come to see a lawyer because they can't handle the situation they're in by themselves anymore. And so thinking about that, they don't have a whole lot of cognitive bandwidth. And they're coming on board with one of the most complex consumer purchases that you can make. It's, the thing that really, really came across to me in all my years of complaint handling is that clients don't understand what they're buying and lawyers don't explain what they're selling. And they often have a bit of difficulty actually describing what it is they're selling. The majority of lawyers know that it's essential to set some realistic expectations at the beginning of the matter, but this continues to be a problem, particularly where things have gone off the rails. The clients have got a lot of stuff going on in their heads. They might have done their own research. They might have asked ChatGPT for an answer. Great move. They might expect some sort of dramatic vindication. And as you know, it's really essential to explain the difference between perceived reality and actual reality. So don't discard anything useful that they've picked up, but it's really important to emphasise that legal matters often don't travel in a straight line. And also don't expect them to take on board virtually any information that you deliver only once and only orally. If you talk to them about expectations, you really need to record the conversation and they need to have a record of it. You might do a short Loom video, you might do a brief, easy to understand letter of advice, but have a record of what you've agreed on as realistic expectations. With the first appointment, this is actually one of the most critical stages of the lawyer-client relationship because this is where expectations and the relationship really start to develop. It's very important to help people prepare for that first appointment. People often feel better if they have a job to do, that it's giving them some agency. So set them tasks to do, some information to gather to prepare for the appointment. If they need to, let them involve a support person, but you really need to set up some clear parameters with the support person, that they're there to take notes, to ask you to slow down if they can see that the client's not understanding what's going on, but they don't talk for the client. They're not their client's advocate to you. Make it as easy as possible for the client to get to the guts of the story. So a pre-intake form can help the interview to be much better use of everybody's time. And one of the interesting developments is on AI agents, which are kind of like second-generation chatbots. I think there's a lot of potential for that kind of use of AI to help with the pre-interview intake. The most important thing to do, as mentioned before, is to agree on realistic goals. So record it in writing or even in a short video. And it's important to mention that a legal matter can be quite dynamic and complex and changeable, and this is totally normal. If you don't set this expectation that things can change, people can perceive totally normal events as being your fault and evidence of poor service. I think it's really important to have a few homely pictures and illustrations up your sleeve to explain what your role is. So in litigation, I really like the idea of being a Sherpa or an expert guide. So you paint the picture, you're just about to go on a long hike together over difficult and, for them, unfamiliar terrain. But you know it like the back of your hand. And so you can help them get to the destination safely. You know what happens if there's a storm and you need to take an alternative route. You can help them get there safely. So a guide, I think, is a really good illustration. If you're stumped on an illustration that you think is appropriate for your kind of service, you could go on ChatGPT and, describe basically what you do and ask it to help you come up with some metaphors or illustrations that will help a client to understand the nature of your services. Quite useful for that sort of stuff. There's a lot of other stuff that it's not useful for at all, but that's a different masterclass, so I'll leave that there. Now, following the first appointment, the next consideration is a realistic cost disclosure. And I think it's really important to think about who is this for. I think for a lot of us, and a lot of the agreements that are floating around the profession are really designed for the regulator's benefit or for the court's benefit, but they're not really great for the clients. But they do have to have these inclusions in them. So picking up on the uniform law, they're fairly similar kinds of obligations in non-uniform jurisdictions. But you're obliged to make the disclosure as soon as practicable. You need to give the basis of the calculation of costs and an estimate of the total legal costs. So the basis of calculation is whether it's fixed fee, hourly rate, hybrid, or whatever. You also need to give them their section 174(2) rights, which are things like the right to negotiate, which is a bit of a meaningless right in practice. There's also the right to be told about the cost disclosure, the right to receive updates, and the right to approach the Legal Services Commissioner in whatever state you're in to make a complaint or get a costs assessment. There's also the importance of giving updates, that as soon as something changes from the beginning of the matter, you tell the client as soon as possible and talk to them about the implications of those changes cost-wise, so that they can make an informed decision about what to do. If you're thinking about your actual cost disclosure and engagement document, is it compliant? So I think that's the basic first issue. It does need to tick off all the boxes in terms of the requirements of the legislation that you operate under. And sometimes that's a little bit difficult to establish, and sometimes it's a little bit difficult to do concisely. I think a lot of the costs agreements that I've seen suffer from the TLDR syndrome. So too long, didn't read. You have to ask, does what you're giving your client actually mean anything to them, or is it a massive crunch in gears compared to all your other communications? So there's a lot of research to indicate that, particularly where you've got a vulnerable client in a difficult situation, they're not going to be able to make sense of a really long document in, legalese, basically. Like, they're more plain English than they used to be, but they're still difficult to read and understand, and a lot of people simply don't bother. I don't think this has to be the case. I think there are ways of making them clear and navigable and in a really good format that works well for clients. But I think a lot of the documents that are out there at the moment really do you a disservice in that regard. And I think it's also worth saying that if they can't understand the document, they might start to think, gosh, is this lawyer pulling the wool over my eyes? What am I signing up for? So there's just all sorts of issues there. For uniform law jurisdiction, one of the sections that's a little bit underrated and that I think really should apply to everybody is you need to take the client through the costs agreement and get their consent and understanding to the course of action that you're proposing, and making sure that they understand the costs that they're up for. So I think that active approach where you talk to them about what's involved and how much it's going to cost and so on, making sure that you really do know that they understand. So this means going beyond simply sending out the agreement, saying, have a read through it and call me if you've got any questions. I think a lot of people won't bother to read it. They'll just sign it and say, well, let's get on with it. So a good costs agreement has a number of characteristics, I think. Firstly, I think it's really, really important to actually include in the costs agreement and to spell out the facts, the goals and the assumptions. So the facts are what you know at the time that you're making the costs disclosure, the goals, the client's goals in the matter, so where you're going to go, and the assumptions that you're making. So you're assuming that the level of conflict will be reasonably low, that the parties have basically agreed on their arrangements and just need to negotiate a few things. All of those sorts of things I think is really important, and because that really informs the scope of what you are saying to the client you're going to do for them. So say, for example, if you think that it's going to settle before mediation, that's going to impact on the scope and the price that you give to the client. So spell out the scope and the contingencies. The thing that is really important about this is if you do this, it gives you a really solid starting point. It gives you baseline information from which it's easier to say to the client, look, this issue here has changed and this has this impact. So it's really insurance for you to make sure that the costs updates, if they're necessary, can be given in a clear and meaningful way. The client has particular things that they want to know when they first engage you, and this again is based on research from the Legal Services Board in England. They want to know, who's my contact? What do I need to do next? How much is this going to cost? How long is this going to take? So really some sort of basic information needs to be brought up the front and presented in a way that's clear for the client to understand. I don't like those costs agreements where the actual disclosure amount is buried around clause 7. I just don't think that's a very good way of presenting it. The format and structure are really important because you actually do want to expect that the client will be able to read it. So it needs to be clearly navigable. It needs to have clear sections. It needs to have little summaries that explain what's in this section and why you need to know it. The good thing about having a costs agreement like this is that it really gives you confidence to talk about money and value with the client. So they can see, it's really letting them into your process, your mental process, when you're thinking about what's going to be involved for them and how it's going to impact on them and what kind of work is involved. Keeping them informed and taking them on board as a partner in that process will really clear up a lot of misconceptions and will help to build trust. When it comes to costs estimates, most lawyers will say this: how long is a piece of string? Now that that quote came up in some more research that I would love you to read from the Victoria Law Foundation called, there's a piece called Pricing Practice that was published late last year. So this was research that we commissioned when I was at the Legal Services Board, and I had a big part in commissioning in this piece, which I was just thrilled with how it turned out. So we got them to interview about 20 accredited specialists in probate and estate and in family law, because they're the two highest areas of complaint, and talk to them in detail about how they scope their matters, how they talk about costs with their clients, all of those sorts of things. It's absolutely invaluable reading. So it's full of gold. So to get better estimates, though, some of the things that came out were, having a comparator class. So as I said at the beginning, with the 14,000 complaints, I could see the patterns in the complaints in a fairly intuitive sense. I think we all operate like that. We can kind of get a feel for it, but we don't kind of surface what that intuition is. So for everybody will say, well, every matter's different, and to some extent they are. But say for example, with a property negotiation that results in a binding financial agreement and consent orders, you know what the stages are. So think about building up a comparator class. So if you've got a matter where you think, well, the initial fact finding was relatively straightforward, we negotiated on this point, and this point. This is where something went wrong, which blew out the costs a bit, but this is how it resolved. So thinking about the stages, thinking about the outliers, where things blow out and where things are fairly predictable. And that will give you a comparator class of matters by which you can get a much clearer and, I guess, more scientific sense of how much a matter is likely to cost based on what you can see in front of you. When it comes to billing methods, I'm often asked, what's the difference between, are there billing methods that are less likely to cause complaints? I think that's an interesting question, because I think on first blush, fixed fees are more desirable for a client, in that they have a much better sense of how much this whole, this part of the matter is going to cost. But when it comes to the actual complaints, I mean, not many fixed fee matters were complained about from what I saw, but I don't know if that's because it's not common or because the lawyers that actually take the trouble to scope out their fixed fee properly are more likely to be client-centric lawyers. But when it comes to the complaint, it's really the relationship that goes off the rails rather than the billing method. So if you're clear about what your costs are, if you're good at making estimates properly, then the hourly rate is okay. The fixed price rate is okay. The thing that really matters is the relationship and whether the client continues to trust you and respect your advice, in which case they'll consider you good value for money, or if they're unhappy for whatever reason, which we'll discuss later. Another question that comes up quite frequently with costs estimates is, do you scope for the short, medium or long term? So, you see a lot of costs disclosures where the client scopes right up to trial, even though, in that particular type of matter, the number of cases that actually go to trial would be less than 2%, and you don't see any particular indications that it might get there. I think what you want to do is scope on the basis of what you see. So if you can see from the information that you've got, from the preliminary inquiries that you've made, from talking with the client, that the matter's likely to resolve prior to negotiation, you just say to the client, I'm scoping it up to, on the basis that prior to mediation. I'm scoping it on the basis that we'll settle before mediation. So that's a good way of doing it. But in that context, you might want to also give them some information about what kind of costs they're likely to be facing. Say, for example, if things go off the rails during the negotiation and you do need to go to mediation, give them an indication of how much that's going to cost. And because that's in your, just in your surrounding information, and you don't need to worry about a precise figure there. You can give a range there, and similarly tell them what litigation is likely to cost. So those are the sorts of tactics that you might have there. If you get a really, really complicated matter where you know that you need to do a lot of digging in to really establish what the facts are, one of the things you might do is consider a short-term scope. So you might just scope for an investigation and option generation phase of the engagement. So say to them, I can see that this is really complicated. What I'll do is dig into the facts, get a really clear understanding of what sort of situation you're facing. Then I'll give you some options with prices attached to those, or range or approximate fees attached to those. So basically you get to the end of it, the client has got something valuable in that they've got the advice and they've got the options, and then you engage on a new scope to take wherever you decide to go with the client. I think it's also good to set some ground rules with clients. So communication, it's really good to put some structure around that. So one lawyer that I know and respect very well who does personal injury matters, there are long phases in the kind of work that he does where you're waiting for the injury to settle, or you're waiting, there are sort of long gaps where nothing much happens with the litigation. But he makes a point of seeing the client, setting an appointment with the client every 6 weeks, just to check in, see how they're going, see if they've got any questions, and then during that appointment, they make the subsequent appointment for 6 weeks, and that way the client knows they've got confidence that they're going to have the lawyer's ear to have that conversation. And they don't need to be worried about calling them and asking questions that are not really necessary during that phase of the agreement. But think about that, putting some structure around the communication. And it's also good to give tips for your client about how they can control costs. For example, writing down their questions, keeping all their documents together so they're easy to access, piling up a few questions and then making an appointment so you can have really have a proper meeting rather than be chasing telephone tag at random. So there's a number of things, a number of tactics that you can employ. And again, the pricing practice research from VLF has a couple of pages of tips for clients, which I think are really useful. Now, thinking about during the engagement, so what things that go right and go wrong during the engagement. There's a big question with what is quality in a legal service. It's very common for a complaining client to say that the lawyer provided poor quality service and it harmed their case. So with the deep dive exercise that I did, we looked at the events and the communications, and it was clear that there was often some sort of supervening event or something the client did or something completely normal in a matter of that kind. For the clients often don't understand the causation, so what caused the thing to go off the rails to their what they perceived as off the rails. And so they revert to a mental model of simpler consumer purchases and put it down to poor service. They found it stressful and confusing. The matter was delayed, must have been the lawyer's fault. Why do they attribute poor quality service to their lawyers? Well, I think one of the things to understand is that lawyers and clients aren't really on the same page when it comes to understanding quality. So the Legal Services Board in England did research on perceptions of quality, and they found that with lawyers, perceptions of quality are always centred on the actual legal tasks, getting the law right, giving accurate, comprehensive advice. But clients have a really different understanding of quality. So they expect that. They expect your accurate and comprehensive advice, but they look at the quality of the service. So what sort of experience did they have? Were your staff nice to them? Was the communication good? Did they feel cared for? Did they feel looked after, or did they feel anxious and not looked after? The outcome is also important from the client's perspective, but again, that ties back to that setting of expectations question. If you can communicate well and set realistic expectations all the way through, the client's understanding of a good outcome can be modified. So you don't leave them with the understanding that they had right at the very beginning of the matter before you advise them. Take them on the journey with that. And I think it's really important to remember the dynamism of many legal matters. They change. So how do you manage setbacks that were outside of your control? How did you prepare the client for them? How did you work out a strategy on how to deal with them? Did you keep working on a cost-benefit analysis with the client to guide them to make decisions that they felt comfortable with? These are all issues that build or detract from a sense of quality. And that relates to value. And again, there are different perceptions of value between lawyers and clients. Lawyers tend to look at value in terms of how much time they put into a matter, whether they did the work efficiently and effectively, whether the hourly rate is appropriate. So very much on input costs. But the clients have a much more varied and nuanced understanding of value. It includes a lot of different factors. So they have to think about, do the benefits of the service outweigh the cost? So not only in terms of finances, but stress and effort and emotional angst and time. So underpinning the evaluation is what benefits the client might be expecting to gain from the purchase. So where you've got a forced purchase, where the client has to retain your services, it'd be reasonable to say that consumers want things like this. They want the problem solved. They want to reduce their anxiety. They want to reduce risk and cost. They want to simplify complexity. They want to avoid hassles, and they want to improve their general well-being. They want to be better off at the end of the matter than they were when they came to see you. So they assume your technical competence, but they really care about whether you're in their corner, whether you care about the matter, whether you're going to give them assurance and support, and sometimes even a bit of tough love. So the roadblocks, here we are. I love this picture. It's a bit like a Victorian country road. I don't know if there's any Victorian practitioners with us today, but that's a bit of a notorious thing. So some of the roadblocks can be the supervening events that are outside your control. So things like court delays, the other side's conduct, the kids not coping with the arrangements that have been previously made. If there are already tensions with the client and things that you haven't explained that are required to deal with it, this can be a big cause of dissatisfaction. Out of scope work can arise as a matter of, because of these sorts of things. And again, this is where it's really important to have your facts, goals and assumptions spelled out in your cost agreement at the beginning, because you can say to the client, hey, look, this assumption no longer holds, this fact has changed, this new fact has arrived, this means I'm going to have to do this extra work, this is what's going to be involved, this is how much it's going to cost, is that okay with you? So the client will be able to see that there is a clear change to the circumstances, and so you give them a fresh scope and give them an update. A lot of the roadblocks are relational roadblocks. So from the client's end, you're looking at things like persistent, unrealistic expectations by the client. Again, that's a difficult thing to manage if your tactics so far haven't worked. There might be demanding behaviour. Again, that often arises out of client anxiety. And it's important to really set clear ground rules and parameters and to explain to the person the consequences of that behaviour. Maybe the client's not following your advice. Any of those things can really be an indicator of a loss of trust and confidence between solicitor and client, which can sometimes be the basis of terminating the retainer. And sometimes you really are better off just cutting your losses. But sometimes there can be mental health issues with the clients. They simply might not be able to deal with the situation that's in front of them and give you proper instructions. So if that's the case, I think it's really important to ensure that they get support, to get them off to counselling, and to try some tactics to try to help them deal with things in a better way. So just small pieces of information, rather than giving them a huge letter that has lots of things in it and expecting them to get back to you with everything. Doing it in small bites. Again, that might blow out the costs a bit, but the problem is it's better that the client be properly engaged there. So you're going to have to make some sort of pragmatic decision if you're facing a client with those sorts of issues. From the lawyer's perspective, there are common issues that lawyers do that really cause problems. So a couple of them are changing lawyers and changing advice. So changing lawyers within the same law firm. I read this, one of the complaints that I did in my deep dive was it involved a firm that had been acting for a client for a couple of years. During that time, she had 5 different lawyers, and a lot of them gave her different advice. The other thing that this firm did wrong was that they took a very passive approach to actually establishing the facts. And so the client was confronted with a couple of nasty surprises in the pre-trial negotiation that just sent everything off the rails. So it was kind of like a classic case of what not to do. Delays are a problem, especially if the delays are your fault. If you don't have capacity to deal with the matter, sometimes you really just have to swallow your pride and refer the matter off to another lawyer. I think that is much better for the client in the long run. And there were a number of complaints that we dealt with where the lawyer had delayed because they had a mental block or because they had too much work on, and they said, "Oh, I'll fix it." And it generally just made things worse. It's better to bite the bullet early if you're going to be the cause of delays. Similarly, with poor communication, part of the issue there is setting the expectations for when you're going to communicate. So if the client feels like they have to chase you and they've got no idea when they're going to speak to you, that can be a big issue with complaints. And of course, rudeness. So if you're defensive, if you lose your temper with the client, if you've got a good relationship, you can often be cut a little bit of slack. But this is really something that you obviously want to avoid as much as possible. And finally, there's the surprises, and not the pleasant sort. So to give you a couple of examples, the surprise costs estimate update. So as mentioned before, as soon as there's a significant change, you need to tell the client what that change is, what implication it has on their costs and the course of action, and what give them enough information so they can make an informed decision about that. And again, there, scoping out the assumptions and scope of the matter in the first place helps to avert those surprises. It's important also to do this in a timely way. So as soon as something goes wrong, even if you don't know what the implications are and you haven't worked out a strategy yet, to call the client and say, listen, such and such an event has happened, sit tight, I'm going to work through what we're going to do about it and the implications, and I'll be in contact with you in the next couple of days, and we'll have a discussion about what we're going to do. So that timeliness is really critically important. And don't do it just before a mediation or just before a big event, because the client feels like they're over a barrel there. With the bills, I think these scales or lists of attendances are often completely meaningless for a client. It's better to think of a bill as a record of the work that you've done to get the client to a particular stage. So the bills need to be meaningful, so tie them to stages and progress and so on. I think one of the formats that I like is kind of like a narrative bill that tells the client what you've done in the billing period and how that relates to the stages of the matter that you've already scoped out. Now, you might want to attach the spreadsheet to the back of the bill so they can see the details of the work that you've done, but make the bill meaningful. Make sure it helps them to understand what you've done and why it's valuable. And bills, of course, have to be fair and reasonable overall. So that's section 172 in the Uniform Law, and there are similar provisions in other legislation. So what that means is things like, so some of the costs complaints that I saw would have things like where, the client, so the lawyer receives an email from the other side, writes a response and CCs the client. Breaking that down into separate attendances and charging a unit for each of them, where the whole process only took, say, 5 or 6 minutes. That's not cool. So if you get an email, it's really quick. You just you assess it, write the reply, send the reply to the client. If that only takes 5 minutes, charge 1 unit. So that's a real guide there for being fair and reasonable. In terms of handling complaints, I think it's very difficult for a lawyer when they get a complaint. There's always a real sense of panic and, oh my goodness, it's going to be my practicing certificate. That very, very rarely happens. Only a couple of solicitors get struck off the roll per year. And the things that they've done are just completely outrageous, and you could never think that you could commit that kind of professional misconduct by mistake. So it's very important to manage your emotions. It's likely to be a lot less drastic than you think. It's usually a grumble about the costs. It's quite easy for clients to complain, and a lot of them will do it, particularly if they're not happy with the outcome that they got when they tried to raise the matter with you. And that's important to bear in mind as well. With the uniform law, the client does have to try to resolve the matter with you before they make a formal complaint, which is why it's important for you to have a couple of tricks and tactics up your sleeve to manage that early and try to resolve it before it gets into the hands of the complaint handling body. So a few things to remember. So manage your emotions. Don't be defensive. If the client starts talking to you, try not to speak. Try not to be defensive and respond, but just listen. And the magic words, tell me more. Tell me more. So get the client to really sort of talk themselves out and don't argue with them. Just understand what they're saying. And when they've said what they want to say, reflect it back and think about how you're going to manage it there. It's important to remember that the clients often have no reference point for prices or services. It's not well known how much legal matters costs, and when they talk to their friend down the pub about how much their divorce cost and everything, their friend will have completely different circumstances to them, and so it's not really a meaningful comparison. So it's important to again talk about bring them back to the costs agreement, bring them back to the disclosure you made and the expectations that were there. Do resolve it early if possible. Sometimes lawyers just sort of have to go, oh, well, I'll chalk that one up to experience, take a bit of a haircut and just take the matter off your plate so you can concentrate on the work that is satisfying and the clients that appreciate you. And finally, just bear in mind, if you have a compliant costs agreement, it's a bit of an insurance policy for you. So it's presumed to be fair and reasonable if the agreement is compliant and if you've given a proper explanation to the client about the work that you've done. So to conclude, personal law clients need personal care. It's really all about the relationship. That is the most critical factor. And, obviously you want to get your law right, you want to get things done efficiently and effectively, but the relationship is the make or break. That's essentially what you're selling when you're dealing with a personal law client, is you're really selling the support, the relationship, getting them through the process and providing that value. And engagement and costs agreements and those discussions are a really great way to build partnership between solicitor and client as you think about the road ahead and think about how to help them make the decisions that they need to make. So in the references at the end, I've provided a reference to a book called Being Mortal by Atul Gawande, where he talks about a number of different models of being a medical practitioner. The model that he recommends is kind of an interpretive model where you talk with the client about their situation, you let them ask questions, you answer their questions, you get to know them, and you help them to make the decisions that they need to make. So it really empowers the client and gives them agency. I think that is such a good model for lawyering as well. We can look for feedback. What did you do well? What can you improve? Don't forget the magic question, tell me more. Now, I think lawyers can make such a fantastic difference in getting a person from a seemingly hopeless situation to a much better place. So make the most of the journey by understanding it from your client's perspective and giving them the value that they need. The good costs agreement is an essential part of that, but the relationship is really everything when it comes to these kinds of clients. Okay, over to you now. Any questions?
Let me know if anyone has any questions. You can pop it in the chat and then we'll unmute you. I'll kick off with a couple of questions to warm everyone up. A question that I've got is, how often should we be looking at our cost agreement from the perspective of, does this need updating? Are we compliant? All of that sort of thing.
Look, I think the compliance question, if the law changes, yes, obviously you'd need to update it at that point. But I think it's a good idea to kind of refamiliarise yourself with your costs agreement fairly regularly. To update it, to think about what are some of the things that you've learned where it hasn't gone so well, or an issue that the client's a little bit confused about. So those sorts of things I think are important to keep it as a bit of a living document. So you'd probably want to do it as part of your annual business review.
Yeah, awesome. That's great. And also we've got a question from our firm in relation to itemised bills. So you sort of covered it in one of your slides. Currently in our practice, we bill by the hour, and then we give them their invoice with a line by line item with what we've charged for the month.
Yeah.
I started doing it that way a number of years back because there was a lot of queries coming through when people weren't really sure what they were paying for. So we do it that way, but we're considering simplifying it and making it more like, I don't know, just a small piece. What do you think is better, just itemizing it out like that, or just giving a invoice for works done with sort of one line or a narrative?
Yeah, I mean, my sense with bills is that they need to be part of the story that you tell the client in terms of where they're at on their journey. So I do like the idea of, I think it's a good idea to give them the detail to demonstrate that you have actually done the work, but it needs to mean something to them. So, peruse email, how many people know what peruse means? It's just those sorts of wording are, think about the actual descriptions that you put in when you're actually putting your narratives in your time recording software. But I like the idea of a bit of a sort of a cover sheet, a summary sheet. So you'd have a narrative, then you'd have you'd have the costs amount, you'd have all your disbursements and all of those bits and pieces, but you attach the detailed narrative at the back. So the client can have a deep look at it if they want to, but they've already got your summary of it, of what you've done for them. So it gives them the information that they need.
Yeah, awesome. Samuel's got a question. Are standing costs agreements reviewed annually for fixed fees for repeat work for corporate clients okay?
So you're thinking about the question of whether you need to give them a fresh cost disclosure for every new engagement?
Samuel, you can hop off and ask your question.
Hi there. Yeah, that's right. Doing between 20 and 50 separate engagements, or let's just call them tasks, the same thing but repeatedly.
Yeah.
Fixed costs, there's no adjustment to costs for each task, each task has a start and an end in terms of the legal work.
Yeah.
So I've been in the habit of, for efficiency's sake, just setting a standing agreement for that particular service that goes annually, and then it's reviewed each year.
Yeah. Look, I think that's there's a couple of ways of doing that. So you could have that standing terms and conditions. You could describe it as a retainer agreement, for example, or just keep the client updated on, is it like a cost per service? So say, for example, if it's a lease review or something like that, there's the standard fee. You've got the description of the property for which you're doing it, and so on. If you can do it like that and just keep them apprised of the matters that you're actually doing for them, and the costs that are amassed because of that. There's a few different ways of doing it. So, be very happy for you to contact me offline if you want to talk through how to do that. But yeah, I think another thing to bear in mind is if they're a corporate and government client, or I don't know if you're in a uniform law or non-uniform law jurisdiction, the cost disclosure requirements for sophisticated or corporate government clients are nowhere near as onerous as they are for individual clients. So so that's another thing to bear in mind, that you can be a lot more flexible with that kind of arrangement if you've got a corporate government client.
Okay, yeah, they probably are sophisticated for the 5 or so clients I use them with. Yeah, I've got around 10 costs agreements, originally based off the New South Wales Law Society template, but they've been amended over the years. So I was considering coming to you when your name popped up in the Facebook chat a while back.
Yep, great. All right. Well, jump
Thanks
on my
for that.
website, book in a discovery call, and we'll get working. Thank you.
Okay, no worries.
We've got another question here on embedding a very short 3 to 5 minute video link, maybe Loom, in the cost agreement or the cover letter send out the cost agreement. Do you want to expand on that question? You can unmute.
Yes. So the question relates to making sure the clients understand what they are agreeing to, and that there might be changes. So I do a lot of fixed fee and value scoping of my the services I provide. And so far, touch wood, I haven't had any issues. But in some cases, things might change in the middle of the matter, and I would have to change the cost agreement with the client. So the idea, and when you spoke about making sure clients understand what they're signing, I can 100% guarantee that most of my clients just see the document. I've verbally explained to them over the phone or over Zoom. They go through it, their eyes glaze over, they just sign, and they want to keep, they just want the work to start. So what do you think about having a very short, look, nothing too long, maybe 3 minutes max, either in the cover, because we send it out securely in the cover message, and within the cost agreement, saying, no, look, this is the scope, it's fixed fee, this could happen, that could happen, this is the reason why you have to sign it. And what do you really think about that?
I think that's a fantastic idea, Chioma. Very well done. I like that idea very much. So, because I think the clients, it's good for them to be able to refer back if you can sort of talk them through. Here's the costs agreement. Here's the part of it, the different parts of it. This is what you need to know about billing. This is my estimate. This is what the estimate is based on. If they've got that to refer back to, I think that's really, really helpful. And it's much more accessible than a long letter. So I think that's a fantastic idea.
The other great thing about Loom videos, I really like that idea too. I've never considered that for our cost agreements or, initial correspondence out. But so many people don't read even the covering letter. And the great thing with Loom is that you can actually see if they've watched the video. So we'll send, and then there's no reason that couldn't be saved in their file for later, which is a really great idea. So for those of us who are thinking, I really need to get my cost agreement looked at, I've been hodgepodging it all together over the years, what would the scope be for getting cost-wise for getting it all up to standard and compliant? I know that you've recently worked with, who was it, Samantha, and she was very happy with the work that you did. So what would the scope sort of be, or the range?
Yeah, look, for a very basic, like a single costs agreement with cover letters and an update letter, so tailored for the particular lawyer's business, that starts at around $3,000. And the more tailored it is, the more we do a bespoke kind of arrangement. So, but yeah, you'd be looking at starting at around 3,000. I do offer discounts for very new law practices and for low bono law practices. So anybody who's doing low bono work, low cost fixed fee services, I'm happy to give a good discount to.
Well, that's great, because then everyone can sleep at night, and it's something that they don't have to worry about, all for only $3,000. So it's actually really great. Does anyone else have any questions that they might want to ask before we let Jennie go? It's been really awesome having you.
Thank you so much for the opportunity.
Having your expertise for the last hour, and I found it really, really interesting. I've been writing away lots of tips. I've got Femke in the background writing away lots of tips as well. And I know that everyone else has really enjoyed it too. So thank you so much.
That's an absolute pleasure. Thank you both, and happy practicing.
Thank you. See you. Bye, everybody.
Okay. Bye-bye.